ಮಾಡಿದ್ರೆ ಓಕೆ. ಓಕೆ, ಗುಡ್ ಆಫ್ಟರ್ನೂನ್ ಆಲ್. ಫೈನಲ್ಲ? Okay, so which questions? This is there. This is okay. This we have done. Freedom of speech, section 66, clean environment, UCC, adjective. Okay. Now, you can write this to the heading. Scope of fundamental rights in the light of latest judgment of the Supreme Court on right to privacy. In the light of latest judgment of Supreme Court on right to privacy. Obviously, the question is clearly telling examine the scope. So it's more than obvious that because of the right to privacy judgment of Supreme Court, in which one obviously case Puttaswamy case, the scope of fundamental rights has drastically increased. That of course you have to write. Now based on that, again what you have to mention? The other dimension. What is the other dimension? If you increase right to scope to this level, what are the challenges that it is trying to pose? So that you need to, obviously that dimension is very, very important. Then you need to sum up. That other dimension, by now you should have got an idea, but please write this answer first, because first let's write about fundamental rights, then you come to the Supreme Court judgment. Constitution in part 3, Constitution in part 3 and article 12 to 35, Constitution in part 3 and article 12 to 35 extensively deals with fundamental rights. Extensively deals with fundamental rights. Extensively deals with fundamental rights. And what is it famously called as? It is famously called as Magna Carta of Indian Constitution. It is famously called as Magna Carta of Indian Constitution. Magna Carta of Indian Constitution. Fine. And then below that, because the question is about Article 21, linked to that, Supreme Court being the ultimate interpreter of Constitution, Supreme Court being the ultimate interpreter of Constitution, being the ultimate interpreter of Constitution, has given very broad or has expanded, whatever morning that use the term, has expanded the horizons of Article 21. Any words you can use. Being the ultimate interpreter of Constitution has broadly expanded the horizons of Article 21 or has given broader interpretation to Article 21. Given broader interpretation to Article 21. Obviously, what is that? That you link to the context. In case Puttaswamy case 2017, in case Puttaswamy case 2017, Supreme Court said that right to privacy is an integral part of Article 21. In case Puttaswamy case 2017, Supreme Court said that right to privacy is an integral part of Article 21. right to privacy is an integral part of Article 21. Fine. Now, obviously, because of this, what happens? This has increased, the linking sentence. This has increased the scope of fundamental rights. This has increased the scope of fundamental rights. Increased the scope of fundamental rights to include multiple components like under right to privacy or writing as a list you can write A, right against digital surveillance. Right against digital surveillance. Right against digital surveillance. Obviously, what does that mean? That is just one line, just a little explanation. That is state should not intrude. State should not intrude into the private aspects of individuals in the digital context. Means internet, all those things. State should not intrude into or intrude against the private aspects of individuals in the digital life or in the digital context. Against the private aspects of individuals in the digital context. Fine. B, right to be forgotten. Right to be forgotten. Obviously, what is it? It includes removal of the information related to an individual. It includes removal of information related to individual's privacy. Removal of the information related to the individual's privacy from the removal of information related to individual's privacy from the digital context, or you can say from the what do you call as this internet, directly from the internet. Fine. Then reproductive rights of women. Reproductive rights of women. Reproductive rights of women. Obviously related to what? Related to childbirth and care. Related to the childbirth and care. Then bodily autonomy of individuals. Bodily autonomy of individuals. Bodily autonomy of individuals. Then broadly we can also sum up, it also includes components like right to choice, right to food, dress. It also includes components like right to choice, food, dress, etc. Right to choice, food, dress, etc. So that means obviously it has been given a very, very broader scope. Now, of course, what challenge, you can put a subheading itself or you can write a linking sentence. Challenges in the context of, or challenges because of increase in the scope of right to privacy. Challenges due to increase in scope of right to privacy. Due to increase in the scope of right to privacy. Obviously, first major choice is what? Challenge is what? Exactly. Right to privacy versus national security concern. Right to privacy versus national security concern. To tackle challenges like terrorism, drug trafficking, tax evasions. To tackle challenges like terrorism, drug trafficking, tax evasions, etc. Then right to privacy versus right to information. because both are equally important rights. Right to privacy versus right to information, or right to know versus right to information. If you want just a little explanation, people have the right to know about, people have their right to know, or people have the right to know, people have the right to know about, especially whom? About the activities of state. People have the right to know about the activities of state. However, it may compromise, right to privacy of few individuals. Like for example, if you want to know about the so many whatever aspects of the individual life of the politicians, leaders, all those things, but you'll have right to information there, you'll also have right to privacy there of the individual's privacy. It will also compromise the right to privacy of individuals. Then obviously other challenge is what? It may include provisions like right to abortion. It may include provisions like right to abortion. Again, as we wrote mornings in some other context also, same question, I mean say related question. Provisions like right to abortion which challenges or which goes against, which challenges the socio-cultural religious aspects, challenges the socio-cultural religious aspects. Then important initiatives like Aadhaar, census, Bihar census you can say, caste census, important initiatives like Aadhaar, Bihar caste census were questioned for violation of right to privacy. Important initiatives like Aadhaar, Bihar caste census were questioned for violation of right to privacy. For violation of right to privacy. Fine. So then below that you can say state has to use the triple test criteria given by Supreme Court. State has to adhere to, you can say, state has to adhere to the triple test criteria given by Supreme Court. State has to adhere to the triple test criteria given by Supreme Court. This is kind of way forward also, you can say triple test criteria given by Supreme Court. In bracket write those keywords. What are those triple test criteria? Legality, necessity, proportionality. Legality, necessity, proportionality. Adhere to the triple test criteria given by Supreme Court. So that is first under way forward, you can say. Then 2 is what then? Implementation of, obviously the act that you have now, Digital Personal Data Protection Act 2023. 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 Then ensure a delicate balance between right to privacy and right to know. Right to privacy and right to know. If you want, for example, electoral bonds was declared unconstitutional by Supreme Court. For example, electoral bonds was declared unconstitutional by Supreme Court in PUCL case. Electoral bonds declared unconstitutional by Supreme Court in PUCL case for violation of right to know. Right, 19 clause 1 subclause A. For violation of right to know, that is 19 clause 1 subclause A. So it was right to privacy versus right to know. Supreme Court said right to know is important. Fine. Yeah. Then, broader conclusion you sum up. Supreme Court has given very broad interpretation for Article 21. Supreme Court has given very broad interpretation for Article 21 to expand the scope of dignified life. Very broad interpretation to Article 21 to expand the scope of dignified life. To expand the scope of dignified life. However, judiciary has to balance. Judiciary has to balance multiple aspects. Judiciary has to balance multiple aspects so that state will also, or state is enabled, so that state is enabled to meet the larger public interest. So that state is enabled to meet the larger public interest. State is enabled to meet larger public interest. Fine. So this is your broader aspect of examining the scope of fundamental rights, but in the context of right to privacy. Please go through it. Any other points if you want to add or any doubts, please ask or tell whatever. We'll finish off Article 21, then we'll come to other things. Gender angle, we have already written. This is 24. Just copy it once. The recent question. A lot of points will repeat, only that specific things will write. Because 21 is very important. So I am trying to give a little details. Or else you could have broadly summed up also. For this, again, we'll not write the details. Only this part we'll discuss. Law related to, because structuring part you will get a fair idea by now. Or else law, so many points related to privacy, bodily autonomy, reproductive rights, everything will keep getting repeated. See how many questions on Article 21. Probably this is, if you add environment justice also, gender justice also to an extent is related to Article 21 itself, though not everything. If you take like that, probably this is like the 5th question we are discussing on 21 itself. Related to 21, again what you have? Larger current affairs angle from the last 2 years. Which one? Data, Digital Personal Data Protection Act. They have asked a question on that, I think in GS-3. There I think they would have asked as a SNT question, because there you can't ask it as a, I don't know the exact demand of the question, I forgot. Probably it was, they have asked it as a SNT, Science and Tech question. But of course at the core, Digital Personal Data Protection Act is what? Polity related. That will write it now as a current affairs. Then we'll go to other articles. But first let's finish this off. But until here I think I don't have to explain. Clearly they are telling you right to privacy is intrinsic to life and personal liberty, inherently protected under 21. Explain. Directly whatever we wrote, have written multiple times. Remember morning also we wrote how the scope has been expanded to include whatever so and so things. So it has, that part you need to explain, subpart 1. Then in this reference discuss the law relating to, or law means you have to, you can probably take it as what, legal aspects relating to DNA testing of the child in the womb to establish paternity. This is your subpart 2. Paternity, right? So first part is clearly addressed. There is no need to worry much about it. For our concern is what? What is this second law related? I mean second provision or second subpart related to DNA testing of the child in the womb to establish paternity. There what are all the other legal aspects? Just put that subheading directly. Structure you understood, right? Just to, if in case you are able to, I mean not able to structure, first write what? Article 21, what do you mean by that? Or as I told, you can also start with fundamental rights, part 3, article, all that also you can write. But I think this is more direct, easily you can approach. Start with first you should first write the article, theory aspect, exactly what is there. The Article 21 says that no person shall be deprived of his life or personal liberty except according to the procedure established by law. That you need to mention. Then if it's a 10 marker, 15 marker, based on that, directly at least you have to refer which one. Menaka Gandhi case, Supreme Court gave the broader interpretation, dignified life, this, that. Then you have to come to how scope has been expanded to include what all. From morning multiple times we have wrote right to health, what do you call this, privacy, to dignify death, die with dignity, to right to which one, custodial torture, health, education, so many things are there, whatever, write some 5, 6, because that is what is your right to privacy is intrinsic. Okay, right to privacy is intrinsic. Okay, so then, sorry, so you need not have to write everything. Directly first write about K.S. Puttaswamy, and then whatever you wrote for just now case, which one? Yeah, that's scope 1, right to be forgotten, right to possess bodily autonomy, reproductive rights, because they are clearly telling you right to privacy, sorry, is intrinsic to the life and personal liberty. Write more about that. Till there, write Article 21, Menaka Gandhi, and then K.S. Puttaswamy, and then about right to privacy. Then you put the heading, legal issues, directly put the subheading. Or law relating to, also you can say, if you want to use the same word. Legal issues related to DNA testing of the child in the womb to establish paternity. It's not very easy to that moment identify a few points, but there are few laws. And then of course you can bring the how privacy angle gets violated, all those things. Yeah, so just clarify that below. Provisions of various laws. Provisions of various laws. Provisions of various laws deal with DNA testing of the child in the womb. Deal with the DNA testing of the child in the womb. DNA testing of the child in the womb. Like which one? Under that first one, PCPNDT Act. Remember, Preconception, Prenatal Diagnostic Techniques Act. PCPNDT Act. If you have forgotten the full form, write the full form. Preconception, Prenatal Diagnostic Techniques. Techniques or technology? Technology, I think. Preconception, Prenatal Diagnostic Technologies Act. What it says? According to it, DNA testing of the child is not allowed. DNA testing of the child is not allowed except under extreme medical circumstances like genetic abnormalities, all those things. DNA testing of the child is not allowed except under extreme medical emergencies. Except under extreme medical emergencies. Right? Even to establish paternity, legal permissions are required. Legal permissions are required. As I told, some case was going on, I think, because of that they had asked, legal permissions are required. That is under PCPNDT Act. Then other one, DNA testing regulation bill. DNA testing regulation bill. Same, even under this act, DNA testing is not allowed without DNA testing is not allowed without the consent of the individual. DNA testing of the child is not allowed without, right? Then another one, Under which act? Which is not very, very broader one. Under Indian Evidence Act. Under Evidence Act, Indian Evidence Act, now what you call as BS, if in bracket you can say BSS, Bharatiya Saksha Samhita. Now, more or less same provision only you will have. Under Indian Evidence Act, that is Bharatiya Saksha Samhita, same. DNA testing is not allowed without individual's consent. Yeah, that is legal aspects. Of course, you can generate another dimension. In addition to this, there are concerns related to privacy of the child and the parent and the family. There are concerns related to the privacy of the, because anyhow the question is broadly about privacy. Concerns related to the privacy of the child, parent and family. Child, parent and family. Supreme Court in, below that, Supreme Court in, these are all not landmark cases. Supreme Court in Babani Prasad case. Babani Prasad case, Gautam Kundu case. Again, not landmark cases. Babani Prasad. Babani, because it's in Odisha, I think. Babani Prasad, Odisha or Bengal. Prasad Gautam Kundu case said that DNA testing is not allowed. DNA testing is not allowed. Same, nothing. DNA testing is not allowed without the consent of the individual. Without the consent of the individual, even to settle or even to determine paternity. Not allowed even to determine paternity. Even to determine the paternity. Fine. So, plus obviously what all is, so the other concerns. Privacy of family and the child should also be considered. Privacy of the family and the child should also be considered before allowing DNA testing of the child. DNA testing of the child. So, in broadly what we are trying to say is most of the laws, even the Supreme Court judgment, gives higher priority to what? Right to privacy here. Understood? Below another one is there. Sometimes what will happen? In some instances, right to know, in some instances, this is not the womb related, but a grown up child. In some instances, right to know the biological parents. In some instances, right to know their biological parents for the child. Right to know their biological parents for the child. Right to know their biological parents for the child also becomes a concern. Also becomes a concern. Now, obviously, broader conclusion is what? It is a very complicated issue. It is a very complicated issue which involves, right to privacy, right to know, and necessity to resolve paternity issues and family disputes. And necessity to resolve paternity issues and family disputes. Because let's say property related something and property disputes. State or Supreme Court should come up with detailed guidelines. State or Supreme Court should come up with detailed guidelines to address the issue to address the issue in a balanced manner, in a balanced way. Detailed guidelines to address the issue in a balanced manner. Because it's not so easy. If you give more priority to privacy, then paternity or addressing family disputes will become concern. To address the issue in a balanced way. And this was your 2024 question, again about right to privacy. Fine. Then clean environment is there. Just to look at it again, that is also related to your 21. Because again that year some issue was there with respect to the, look at this question again. Does the right to clean environment entail legal regulations on burning crackers during Diwali? And should. This question getting repeated, chances are less, because that year some issue would have been there, and which you would have seen regularly. Some other controversy will be there related to that. The question they are asking is, does it include legal regulations in burning crackers during Diwali? Discuss in the light of Article 21 and judgments of the Supreme Court in this regard. That means what they are trying to say. Obviously, we have mentioned that what MC Mehta cases. So what does it include? Right to clean environment is part of Article 21. That we have clearly mentioned. Agreed. Now, in that context, obviously it includes what? State can put certain regulations on burning crackers during Diwali. Obvious matter, because you can. A lot of facts are there to show that what, because of that the air pollution, this, that, everything increases a lot. All those things are there. Considering those aspects, yes, you can put the regulations. But now the counterpoint is what? Counterpoint is, if you try to put regulations on this, what is also the issue? What is also there? Cultural aspects, religious aspects are also there, which is part of your Article 25, or broadly what you call as the freedom of speech and expression. Now, how will you balance that? If you put too many regulations, or if you literally completely ban the crackers burning, then what will happen to those aspects? If you don't allow, then this issue will get affected. So that's why obviously what you can tell, there are obviously Article 21 issues, Supreme Court judgments. This is getting repeated kind of a thing is not there, because privacy is the major issue for us, or other aspects. Balanced way, what you can tell. First point is what? Broader legal awareness or broader awareness about the issues related to burning of crackers is necessary. You cannot outrightly ban, because there are concerns of what? Cultural and religious aspects. Maybe the state has taken certain organizations already, like what, those green crackers, all those things that you can do. Or maybe as Supreme Court has done, what they can do, they can put certain what time limits or something that they can also try to do. So like that, you cannot, it's better not to take a stand saying that completely ban the burning of crackers is not a correct measure, because it doesn't suit well. Understood? That was asked that year. I think there was no landmark judgment. I don't remember the exact judgment during that time, but that context they have asked. If you want, just copy the question. Very simple one. Not chances of getting repeated is very, very less. What we are going to do now is the most important one. Just note down the question and go search. Again, you will get the same things, MC Mehta cases. I think that some other Diwali related case, Delhi especially, Delhi related air pollution cases. Yeah, now get the current affairs angle, put the heading. A very important one. I think this time you can easily expect it in GS-2. Digital Personal Data Protection Act 2023. Digital Personal Data Protection Act 2023. Digital Personal Data Protection Act 2023. So can you recall few major provisions? Maybe in for prelims perspective also you would have discussed, but from the mains perspective. First, of course, features we need to write. Recall whatever the data is one. Data fiduciary keywords, they are correct. Then data principal, big data not aspect, data fiduciary, data principal, data processor, data localization, sovereignty aspects is not there here, data protection board of India, those are the keywords. Fine, obviously what are the penalties? So what are the exemptions? What about the child related aspects, child privacy related aspects? So all those things. It is not a crime. I mean, broadly you will be knowing that. First is what? Which one? This is based on which one? First of all, yeah, Justice Sri Krishna committee report. Based on that, obviously bill was drafted. Based on that, the issue went to the joint parliamentary committee. So then they gave detailed inputs. Then they have redrafted your Digital Personal Data Protection Act. Within that, if you have observed, there is something called as sensitive personal data. There is something called as critical personal data. Critical data, all those things. Sensitive personal data, it is not so easy to take it outside the country. Other data, you can easily take it. Obviously, you can process the data outside the country also. Now, any kind of violations of privacy, so respective authorities or companies, whatever you call it as for social media companies, they should report it to the data protection board. If in case they don't report and they keep on violating it, what penalties to what extent? Penalties can go up to 250 crore. So to that extent, penalties are being imposed. Obviously, all this will be enforced by whom? Data Protection Board of India, which will be obviously a statutory body, but Government of India will only nominate the members. No courts can look into the issues related to privacy. I mean, the data protection related. Only in the sense minimum high court. No sessions court, no subordinate courts can look into this data protection violations or anything. Clear? Now this is broader aspect. But of course, few data state can compromise this privacy also. Of course, which aspects? If it is related to sovereignty, national security, all those things, state can compromise it. Then another word what they are telling, companies should be very cautious about the privacy related to the children. Children related any privacies, they have to be very cautious. And of course, data principal means who? Data principal means us. So we will have what? We will have the control over our data. We will have the right to consent, right to erase, right to correct, right to grievance redressal, all these also. Right to be forgotten is still not exclusively mentioned. Right to be, that's a limitation we'll write. Right to be forgotten is not mentioned explicitly under which one act? 2023 Act. But other things are there. You can give the consent, you can take it back, erase, correct, grievance redressal if in case, all those things are there. That is principal, data principal's rights. Fiduciary means what? Someone who is collecting the data, storing the data. Normally, if data fiduciary and data processor will be the same. That's our typical social media companies. It can be WhatsApps, Googles, YouTube, Insta, this, that, all of them. Mostly they are the normally fiduciary as well as data processor. Sometimes it might be little different also. Someone may be collecting information, that is fiduciary. Processors are normally our typical social media companies. Data localization, chances, especially sensitive personal data means our what do you call it, gender related, caste related, religion related, all those informations are sensitive personal data. It cannot be sent outside the country, very difficult. Or they can take the permission and the data protection boards and then they can take it out. Critical data, that is also not allowed, means data related to India's security or sovereignty not allowed to be taken outside the country. Whichever data that government declares as critical data cannot be taken outside the country. That is the aspects related to what? Data localization. Clear? Earlier in the original bill, if you observe, there was provisions called as data mirroring also. Means one copy, whichever any information you take outside the country, one copy should be there here. Data mirroring. I think in the 2023 Act, they have taken out that provision of data mirroring. Earlier, data sovereignty was a major issue. Means Government of India will have the ultimate control over all those things. Now that word is not explicitly mentioned in 2023 Act. Those are all the criticisms. Of course, they have taken so many measures under this act. This is going to be one of the most important acts, considering the way, imagine how much of information will be generated in the next few 10-20 years because of the penetration of internet and artificial intelligence, internet of things, this, that. Imagine how much amount of terabytes or whatever the next one, zillions of whatever data will be generated. This is very, very important act. But there are concerns, as I told. For example, Data Protection Board of India, all the members will be appointed by whom? Government of India. Obviously, that means they will give major priority to whom? State interest. So what if the state itself violates privacy then? That concern is also there. Then small concerns what they are trying to raise is that what? So if you put so much of penalties and all those things are strict regulations, so what about the innovations in all this, whatever social, what you call internet related startups and all those things? What if that is going to be compromised? Or the compliance costs, means the data are, the provisions are so detailed, how do you expect small startups to comply with all these provisions? Means that itself burden, means you have to, they have their details like this, every company should appoint a person, any data breaches they should respond to them, any cases there will be huge penalties, all those things, that is a compliance cost. Again child related, so what about the parental concern? First of all, what is the definition of the child? They have told less than 18. So now child related definition also, parental concerns, how to regulate the OTT companies in this context, that also has become a challenge. Like that, so many challenges are there. As I told, right to be forgotten is still not mentioned, data sovereignty is still not clear, data localization also there are challenges, and on what basis will state declare some data as sensitive personal data and some data as critical data. There is no clarity about the definition. Whatever government decides is the final aspect. Like that, a lot of challenges are there, fine, but whatever said and done, it is one of the most detailed acts, and what is it also? It has gone through the complete detailed parliamentary scrutiny. It has been introduced in parliament detailed, almost 3 to 4 years they have discussed. 2018 or 19 was a bill introduced, passed in 2023. Very detailed discussion in joint parliamentary committee. I think twice or thrice they redrafted it. So collective responsibility aspect, very detailed parliamentary scrutiny. Despite concerns, we need to always support this act. Clear? So this is a very bigger picture. Easily you can expect a mains question. For some reason, 2023 also we expected, 24 also we expected, but they have asked in paper 3 in the beginning itself. I told this year, if they ask in paper 2, obviously larger question they'll ask, either they link it to right to privacy angle, or if they ask it as a legislation question itself, what they'll ask? Salient features, critically analyze the provisions. That's a direct question. Who knows? They may link it to right to privacy or digital innovations, or we don't know, artificial intelligence or fourth industrial revolution. We don't know how they are going to interlink. Anything they can interlink, but first put the heading Digital Personal Data Protection Act 2023. First tell the context. How was it introduced, or what it is based on? What? Exactly, it is based on the report, or it is based on Justice Sri Krishna committee report on data protection. That itself was based on what? Supreme Court case put us for me. It is based on Justice Sri Krishna committee report on data protection. Justice Sri Krishna committee report on data protection. Now later what happened? JPC, Joint Parliamentary Committee on Data Protection Bill, gave detailed inputs. This is the context you are setting. JPC report on the data protection bill gave detailed recommendations, or detailed report, gave detailed recommendations based on which the bill was redrafted and passed in 2023. Based on which the bill was redrafted and passed in 2023. The bill was redrafted and passed in 2023. Fine? Yeah. Now write those important salient features. Yes, there will be still so many, but whatever major features that I can recall, I'll tell everything. You can go and add 1 or 2 if it is missed out. First one, data principal. Data principal. Obviously, who are they? Individuals whose personal data is collected. That means you take it as common man like us. Data principal. Individuals whose personal data is collected. And what rights they will get? They will have rights like, or they'll have the rights related to. They will have the right to consent, correct, erase or correction, erasure, they will have the right to consent, correction, erasure and grievance redressal. Grievance redressal. Then data fiduciary, FIDUCIARY. Data fiduciary. What are they? Organizations who collect, store the data. Organizations who collect and store the data. Collect and store the data. Then data processor. Again, the name itself says data processor, means data analytics, everything, whoever uses that. Organizations who process the data. Organization who process the data. Normally, social media companies are both data fiduciary and processors. Not necessarily, normally. Normally, social media companies are both data fiduciary and processor. Data fiduciary and processor. Data fiduciary and processor. Then digital personal data. Digital personal data. The name itself says, word itself says everything. Related to individual's name, religion, caste, age, gender, that is sexual orientation, everything. Related to the individual's name, religion, caste, gender or sexual orientation, whatever words. Name, age, religion, caste, sexual orientation, etc. Then critical data. The name itself says data declared by the government as critical. Data declared by the government as critical. Declared by the government as critical. Is mostly related to the sovereignty security issues. Then this act applies not only to processing of data within India. This act applies not only to the processing of data within India. It applies not only to processing of the data within India, but also not only to processing of the data within India, but also outside the territory of India, but also outside the territory of India. Not only to the processing of data within India, but also outside the territory of India, if it is related to providing goods and services in India. If it is related to providing goods and services in India. If it is related to providing the goods and services in India. Related to providing the goods and services in India. Fine? Yeah, so then Data Protection Board of India. Data Protection Board of India. Obviously, the name itself says quasi-judicial authority. Data Protection Board of India. Quasi-judicial authority with adjudicatory powers, judicial powers. Quasi-judicial body with adjudicatory powers. Adjudicatory powers to resolve any disputes related to data privacy or violations. To resolve any disputes related to data privacy violations. Resolve any disputes related to the data privacy violations. Data privacy violation. Fine. Obviously, what are the penalties? Penalty up to, that is maximum, penalty up to 250 crore. Penalties up to 250 crore. Fine. But obviously what is not there, just for your clarity, there are no criminal charges or there are no criminal penalty, in other words sentences. There are no criminal cases. So it's just a civil case, there are no criminal cases. Then its orders, means Data Protection Board orders, its orders can only be questioned in, as I told, where? High Court. Of course, finally Supreme Court is always there. Its orders can always or can only be questioned in High Court. Can only be questioned in the High Court. Can only be questioned in the High Court. And then state can exempt. State can exempt. State can exempt certain or data related to certain issues from the Act. Information related to certain issues from the Act. In other words, state can compromise. Obviously, which one? Exactly. State can use information or data related to certain issues from the Act. Yeah, write those with respect to or concern to national security, sovereignty, integrity. So for all those things, they can compromise privacy, you can't question. Sovereignty, integrity, national security, etc. Then what can't be compromised? Children related information and privacy cannot be compromised. Means their tracking, everything is not allowed. Children related information and privacy cannot be compromised. Cannot be compromised. Parental consent is required. Children related information and privacy cannot be compromised. Parents' consent is required. Parent consent is required to collect any data related to children. Parents' consent is required to collect any information related to children. Any information related to children. Fine. Yeah, broadly these are the major features. Now of course the critical part means significance first and then criticism. Significance of the Act. Significance of the Act. Obviously first one is what? It tries to uphold right to privacy, which is intrinsic to Article 21. Tries to uphold right to privacy, which is intrinsic to Article 21. Which is intrinsic to Article 21. Then it is in tune with global standards or global regulations like obviously the world's famous is what? European Union GDPR, General Data Protection Regime or regulations. It is in tune with the global regulations like European Union GDPR, General Data Protection Regime or regulation. General Data Protection Regulation. Fine. Then 3. Data processors means largely the internet social media companies. Data processors and fiduciaries if you want. Data processors and fiduciaries are made accountable to their actions. Means looking at the provisions you have to just keep generating. You can't ban all these ones. Data processors and fiduciaries are made accountable to their actions. Obviously what you have to do, any violation or breach, whatever, any violations of private data should be immediately informed to the respective authority. That's what is Data Protection Authority. Any violations of data privacy should be immediately informed to the DPDI, that is, or you can say authority. Should be immediately informed to the concerned authority. Immediately informed to the concerned authority. Fine. Yeah, there's another one. Next one. What are you going to say? It tries to balance. It tries to balance privacy and national interests. tries to balance privacy and national interest. Same way what it tries to balance? Tries to balance privacy and national interest. Then children privacy is protected. Children's privacy is protected. Children's privacy is protected. Yeah, and the same way you have penalty mechanism, all those. Then criticism. I've told you, summed up, right to be forgotten is not explicitly mentioned. Right to be forgotten, limitations, criticisms, whatever, is not explicitly mentioned. Right to be forgotten is not explicitly mentioned. Is not explicitly mentioned. Then compliance burden on small companies. Big companies is fine, small companies. Compliance burden on the small companies. Compliance burden on the small companies. Fine. Then next one is what? Social media companies. GAFA, what you call it as? Social media companies have raised concerns related to over-regulation, thereby compromising digital innovations. Social media companies have raised concerns related to over-regulation. Concerns related to the over-regulation, thereby compromising, affecting data, or you can say digital innovations, digital research and innovation. Digital research and innovation. Then members of DP, that is Judicial Personal Protection, Data Protection Authority, Data Protection Board. Members of Data Protection Board obviously are what? Are appointed by Union Government. Members of the Data Protection Board are appointed by Union Government, hence obviously which bias? Exactly. Hence they will be more biased towards the state. Members of Data Protection Board are appointed by Union Government, hence they will be, or they, chances that is, they will be more biased towards the interests of state. More biased towards the interest of states. Then original bill had provisions related to data mirroring, localization and sovereignty. Original bill had provisions related to data mirroring, localization and sovereignty. Data mirroring, localization and sovereignty. These issues are not explicitly mentioned in the 2023 Act. These issues are not explicitly mentioned in 2023 Act, or not explicitly mentioned in 2023 Act. Yeah, so this is broader aspect. Then as I told, broader conclusion, say more or less where the same question comes, in and around you can change a few keywords and you can make use of the same one. 2023 Act. 2023 Act is one of the landmark legislations. 2023 Act is one of the landmark legislations. One of the landmark legislations of 21st century. Landmark legislations of 21st century in the context of one of the landmark legislations of 21st century in the context of, obviously which one? Fourth Industrial Revolution. In the context of Fourth Industrial Revolution, artificial intelligence and knowledge economy. Fourth Industrial Revolution, artificial intelligence and knowledge economy. The Act has extensively tried, or that the Act has extensive provisions. The Act has extensive provisions to protect data privacy. Extensive provisions to protect data privacy. However, However, certain concerns related to overarching power of the state, certain concerns related to the overarching powers of the state, overarching powers of the state and absence of data localization and sovereignty provisions. Absence of the data localization and sovereignty provisions needs to be effectively addressed. You can say that means in the future amendment, something like that needs to be effectively addressed. This is broader one. Of course, you can go through, you can add few provisions, criticisms, everything. There's so much of content, I don't have to even talk about it. But if you know even largely like 70-80% of this, any question on Data Protection Act, you can easily manage. Because as I keep telling, evaluator will be looking for certain keywords. Like if he finds keywords like data principal, fiduciary, processor, or data protection authority, or national estate interest, data localization, sovereignty, automatically he will get an idea that okay, you know that content or you know the points related to this particular act. Clear? That is one. I think 21 we have broadly discussed enough. If in case there are any issues related to current affairs, constitutional morality will discuss under your amendment of constitution basic structure. Anyhow, there is a question, one question that anyhow will write, UCC will write later. EWS is not exactly related to it. Last year also we had made a question on that. I'll show you if you want, because I had made a broader question because Janhit Abhiyan judgment from 2 years we are repeating that case, but again I am not sure if they are going to ask it again. What is that? Constitutionalism, basic structure, constitutional morality. Last year we expected, I mean, because there was, remember 23 there was a question on principles of natural justice, that also I had made. These are all, this one what you call it, theory based questions, that all will write, but first I will show you this question on reservation broadly. Remember this year also you had a question on which one? Just Supreme Court judgment is there, subcategorization of, that also will write. Reservation issues, because one or other time continuously reservation issues are in news. Women reservation, you will it, that will discuss under your parliament chapter. This is one judgment they have given, I mean the previous judgment this is, which one? Supreme Court has recently upheld EWS reservation 2023 case. Enlist the, what we need to take, constitutional provisions related to reservation, write a note on Supreme Court's opinion on reservations through various judgments. Because reservation is in use, they are writing this. What we'll do, we'll make a broader aspect, again include as current affairs, which one? Subcategorization of SC, ST. You'll vote EWS. Yeah. So put this as subheading, put the broader subheading. Give the current affairs stretch itself, then we'll go back to the basics. Subcategorization of SC. ST subcategorization is still not there. SC only we are talking. Subcategorization of SC. Subcategorization of SC. But of course, before you come to this, what we need to understand, the entire provisions related to reservations, you should have an idea. Then we'll talk about subcategorization of SC. This also we normally discuss in your OGP class also. First let's write that. To the subheading, constitutional provisions related to reservation. Of course, Supreme Court judgments, everything you need to have. Normally, UPSC does not try to touch the reservation issues in mains, but maybe at least for your argumentations, everything, 1 or 2 fodder points. Constitutional provisions related to reservations, right, broadly, and then we'll come to the appointment, all those things. As they have mentioned there, that all is later. First, right, fundamental rights part 3. Under that, what reservations we have. Then we'll go to the other things. Fundamental rights part 3. Obviously, what you have first? 15, exactly. Article 15, clause 4. Clause 5 first. They have directly mentioned clause 5 and clause 6. Article 15, clause 5. What is it? Reservations for OBC, SC, ST in educational institutions, including private institutions. 4 is in general welfare measures. Fine. Reservations for OBC, SC, ST in educational institutions, including private institutions. Including private institutions. Obviously, the only exception is what? Yeah, exactly. Not in minority institutions or except minority institutions. Except minority institutions. Then 15 clause 6, EWS reservation up to 10%. Again same, educational institutions, all those things. 15 clause 6, EWS reservation up to 10%. If you want, just repeat the same. In educational institutions, including private institutions, this is what? 103rd Amendment 2019. That is the context. For this question, that is the context. Fine. If you want, just write that upheld by Supreme Court in Janhit Abhiyan case. Upheld by Supreme Court in Janhit Abhiyan case. Then 16 clause 4. 16 clause 4. State can reserve state can provide reservations. State can provide reservations in favor of any community which is state can provide reservations in favor of any community which is not adequately represented. Provide reservations in favor of any community which is not adequately represented in the services. Not adequately represented in services. Not adequately represented in services. Then directly read this. 77th Amendment 1995, 16 clause 4A added. Not a landmark amendment, but 77th 1995, 16 clause 4A. Article 16 clause 4A added. Reservation in promotion for SC and ST. 16 clause 4A. Reservation in promotion for SC and ST. Reservation in promotion for SC and ST. In promotion for SC and ST. That's in fundamental rights. Then they have talked about each one. Okay, this one also they have mentioned. 81st Amendment 2000, 16 clause 4B, which is what? Carry forward. 81st Amendment 2000, 16 4B. Carry forward of the unfilled vacancies. Carry forward of the unfilled vacancies related to SC, ST. Carry forward of the unfilled vacancies related to SC and ST. This is in fundamental rights. Of course, others you know, 330, 332. Reservation for SC, ST in, this is broadly they are telling everything, anything related to reservation provisions. Because how they ask constitutional provisions related to gender justice, if they ask constitutional provisions related to reservation, though no single question related to reservation topic in the GS-2. 330, 332. Reservations for SC, ST in Lok Sabha Assembly. 243D, 243T. Reservation in Panchayat and Municipality. 243D, 243T. Reservation for SC, ST in Panchayat municipality. 243D is Panchayat, T is municipality. If you want women angle, 330A, 332A. Same, women, Lok Sabha, Assembly. Yeah, this one also you can say. 330A, 332A. Then 335. 335. The interests of SC and ST. The interests of SC and ST should be protected without compromising efficiency, or they have used the term efficacy of administration. Actually, efficiency itself is the word. Interests of SC and ST should be upheld without compromising efficiency of administration. Without compromising the efficiency of administration. Remember, this was your 2023 one of the prelims question. Without compromising efficiency of administration. Yeah, so Champakam Rajan case, everything is there, but let's go to the landmark cases. Before this, of course, the landmark case is what? Indira Sani case 1992, sorry. Indira Sani case 1992. Because without that, you can't write any question on reservation. 1992. Of course, first one is what? OBC, 27% OBC reservation upheld. 27% OBC reservation upheld. 27% OBC reservation upheld. 2. Creamy layer within OBC to be excluded. Creamy layer within OBC to be excluded. Creamy layer within. This is largely your basic aspects itself, but we link it to that because of the subcategorization of SC judgment. Creamy layer within OBC excluded. 3. 50% limit for the overall reservation except in extraordinary circumstance. 50% limit for the overall reservation except in extraordinary circumstance. Except in the extraordinary circumstance. No EWS reservation. This was in 1992. No reservation for EWS. No EWS reservation. Then no reservation in promotion. No reservation in promotion. Then permanent statutory body to implement OBC reservation. Permanent statutory body to implement OBC reservation. To implement OBC reservation. Fine. Then this case, M. Nagaraj case, triple test criteria. M. Nagaraj case, triple test criteria. Triple test criteria for reservation in promotion for SC and ST. Triple test criteria for reservation in promotion for SC and ST. Triple test criteria for reservation in promotion for SC and ST. Obviously, what are those? A, first one, backwardness of the community. Backwardness of the community in the top services, top level of the services. Backwardness of the community in the top services. In the top services. B, quantitative data. Quantitative data means to prove the backwardness. Quantitative data to prove backwardness. 3, efficiency of administration should not be compromised. Efficiency of administration should not be compromised. Then if you have forgotten, Jarnail Singh versus Lakshmi Gupta. Jarnail Singh versus Lakshmi Gupta. Jarnail Singh versus Lakshmi Gupta. What is it? Reservation in promotion based on consequential seniority. Of course, they told creamy layer should be excluded. In general, creamy layer within a not SC ST, only in promotion aspect. Reservation in promotion based on consequential seniority. Based on consequential seniority. Yeah, now the recent. You can put the subheading if you want. Subcategorization of SC. Subcategorization of SC. First point you tell, there is no subcategorization of ST as it is considered homogeneous community. No subcategorization of ST as it is considered homogeneous community. Homogeneous is the key word. Means the moment you are considered SC, so there is nothing like forward SC, backward SC is what Supreme Court has, as of now, that is a provision, stand, as it is considered as a homogeneous community. Considered homogeneous community. Same, what reasoning we had taken in which case? E.V. Chinnaya versus State of Andhra Pradesh. E.V. Chinnaya versus State of Andhra Pradesh, same logic. E.V. Chinnaya versus State of Andhra Pradesh. No subcategorization of SC, same reason, as it is a homogeneous community. No subcategorization of SC as it is homogeneous community. It is a homogeneous community. Now which case? Davinder Singh versus State of Punjab. Davinder Singh versus State of Punjab. Subcategorization within SC allowed by Supreme Court. Davinder Singh versus State of Punjab. Subcategorization within SC allowed by Supreme Court. Subcategorization within SC allowed by Supreme Court, as the reason is simple, same logic, reverse, as SC is not a homogeneous community. As SC is not a homogeneous community. See, completely the arguments have opposite now. It is not a homogeneous community. Fine. So that is a broader aspect that we have made. Of course, we had made a broader question related to reservation itself in general, and you know the arguments in favor, against reservations, how obviously it is needed, all those things, but some challenges are there. That is the one. Subcategorization within OBC, not necessary here. Fine. So then, what other current affairs issues are there? Hate speech we'll discuss. Before that, let's go to the PYQ again. On 19 clause 1 subclause 2 you have two questions. This is first and this is another one. Just look at the question. Clearly they have mentioned three parts. Again, you can't get it get the pattern repeated. What do you understand by the concept of freedom of speech and expression? Does it cover hate speech? Why are films in India stand, or why do films in India stand on a slightly different flame from other forms of expression? Obviously, we all know that freedom of speech and expression is what? Again, like Article 21, given a very broad interpretation, which includes what all? Freedom of press, right to information, right to silence, right against censorship, creative expression, so many things, right against which one? Tapping of the telephone, conversations, all of those things, very, very broader aspect. So obviously, does it cover hate speech? Obviously, it doesn't cover, which is what? You have reasonable restrictions, 19 clause 2, recall. sovereignty, integrity, public order, decency, incitement to violence, so many things are there. Based on that, it doesn't cover hate speech. That you need to mention. But last year also, I mean, hate speech question again not so easy to expect because it's again a controversial aspect. But Supreme Court keeps on, that's why we have mentioned it under current affairs also, if you have seen. It doesn't include hate speech, no doubt about it. But what is hate speech, all those things? As of today, there is no explicit law to deal with hate speech. There are various acts, provisions of various acts, like of course earlier IPC, now you have which one? Bharatiya Nyaya Samhita, under which hate speech can be punished and all those things, that is there. Obviously, some provisions related to SC/ST Atrocities Act is there, Protection of Civil Rights Act is there. Under those aspects, it can be punished. But there is no one detailed act to deal with hate speech. Under RP Act also some provisions are there. That we will discuss. That's what is the hate speech broadly, just to understand it. Fine, there is no explicit definition also, that aspect. Then third aspect is what? Why are films treated on a slightly different plane? Because that year I think some issue was there related to probably Sham Benegal committee or something, if you recall. Again, not in news, not a current affairs aspect, only hate speech is kind of in news because in one of the cases Supreme Court had told that we need to have a detailed act to deal with hate speech. Yeah, so we will just broadly mention about it. Expecting a question on that, chances are less. Broadly on freedom of speech and expression, one or other issue will keep on going regularly, we all know that. They may try to link, clear? So, other than, I mean, rather than writing, I mean, if you want, write on the question or put a broader heading, freedom of speech and expression, and then under that, hate speech, everything I will try to cover. Freedom of speech and expression. 19 clause 1 subclause A, because another very favorite aspect. Look at this question also, just to understand. Related to 19 clause 1 subclause A, which one? Section 66A IT Act. Obviously, multiple times I keep telling which case? Shreya Singhal case. That will come to that. First, let's write about freedom of speech and expression, 19 clause 1 subclause A. Same, what is the context? It includes the freedom to express. It includes the freedom to express one's own view as well as that of others. Freedom to express one's own view as well as that of others. As well as that of others. Of course, what? Supreme Court has given very broad interpretation to it. Same like the pattern of 21. Supreme Court has given a very broad interpretation to it, means to 19 clauses of clause A. You don't have to remember all the cases, but if in case they ask like that, like how they asked, like Supreme Court has given or expanded the horizons of Article 21, same pattern. What if they ask Supreme Court has expanded the horizons of 19 clauses of clause A? That time at least you should know what are the components, and what if they mention like how morning we discussed, Supreme Court has told us what, I mean UPSC has broadly expanded the horizons of Article 21, illustrate with case laws. What if they ask the same question with freedom of speech and expression, illustrate with case laws? Chances are very high because say it is the second most important one. So mention that. As a list you write at least some whatever, you have so many important ones. First one, freedom of press. Freedom of press. Case laws. I mean bracket write the case. Ramesh Thapar case, Brijbhushan case. Ramesh Thapar case, Brijbhushan case. Brijbhushan case, B-R-I-J, Brijbhushan case. Ramesh Thapar case, Brijbhushan case. Then freedom of creative expression. Freedom of creative expression. Yes, Rangarajan case. Yes, Rangarajan case. Then right to silence. Recall the landmark. Exactly. Joe witnesses famously, officially, Bijo Emmanuel versus State of Kerala. Right to silence. Bijo Emmanuel. If in case you don't recall. Bijo Emmanuel case. Bijo Emmanuel or of Bijo Emmanuel versus State of Kerala. Right to silence. Then right to information or right to know, whatever. Right to information, PUCL case. Right to information, PUCL case. Then right to protest, MKSS, Mazdoor Kisan Shakti Sangathan. Right to protest, MKSS, Mazdoor Kisan Shakti Sangathan. MKSS case. Right to dissent, Bhima Koregaon case. Bhima Koregaon is not the official name of the case. Bhima Koregaon. Right to internet, Anuradha Bashin. Right to internet, Anuradha Bashin case. Anuradha Bashin case. So, if in case, I mean, you still have few. If you want, in addition, you can write. In addition, it also includes what all? Right against censorship. It also includes right against censorship. Right against censorship. Right against tapping of telephone conversations. Right to picketing. Right against tapping of telephone conversation. Right against tapping of telephone conversation. Right to picketing means urging people not to buy a particular product like that. Right to picketing, etc. What it does, okay, this is broadly the aspects. So, exactly same pattern if they ask in the context also how Supreme Court has given broader interpretation to the scope of Article 19 clause and subclause A, illustrate with case laws, you just have to copy paste them, fine. Of course, what you have to always understand, 19 clause 2 reasonable restrictions, 19 clause 2 reasonable restriction, reasonable restriction. Obviously, which one? Just write whatever, 8 grounds are there totally. In mains, you need not write all the grounds. Just for information, you can write few. Obviously, you know, please write them. Sovereignty, integrity of India, security of India, friendly relations with other countries, sovereignty, integrity of India, friendly relations with India, I mean friendly relations with other countries, security of India, security of the state, that is, friendly relations with other countries, public order, decency, these all you know, public order, decency, contempt of court, incitement to offence, etc. Contempt of court, incitement to offence, incitement to offence. Defamation also is there, correct? Defamation. Largely, those are the 19 clause 2. How many we wrote? I think one. Defamation. I think one we left out. Or did I tell? Which one we left out? Incitement to offence I have written. Contempt of court. Defamation. Decency or morality. That you wrote. Public order, decency or morality. Okay, fine then. That is reasonable restriction because that now linked to kind of current affairs angle also. Even in this question, you have with heading hate speech. Hate speech. First, write the broader aspect. Hate speech. There is no clear definition of hate speech. Question directly on this, chances are less. Maybe something like this if they may ask. If in case it comes back in news again in the next two months. There is no clear definition of hate speech, and what you also don't have, no specific act to deal with it. So separate law you don't have. No specific act to deal with it. No specific act to deal with it. And then write the broader aspect then. How can you broadly define it as? It contains, or it is broadly defined as, it is broadly defined as any kind of speech. It is broadly defined as any kind of speech. Any kind of speech which tries to spread, promote. Any kind of speech which tries to spread hatred against particular, any kind of speech which tries to spread hatred against particular community, caste, group, gender, etc., which tries to spread hatred against particular community, that is religion, caste, gender, race, ethnicity, whatever, etc. Obviously, what is it? It is an offence under various acts. It's a crime. It's a criminal offence under various acts. It's an offence under various acts. The major ones you listed, obviously, which one? BNS. IPC or BNS? IPC or BNS? Obviously, 2 is what? SC/ST Atrocities Act. SC/ST, Prevention of Atrocities Act. Protection of Civil Rights Act. Protection of Civil Rights Act. Protection of Civil Rights Act. Then under RP Act, section 120, under section 123 of RP Act, it is one of the electoral offence. Under section 123 of RP Act 1951, it is one of electoral offence. Remember, electoral offence or corrupt practices. It's one of the electoral offence or corrupt practices. Electoral offence or corrupt practice. So these are like broader, we can say what provisions related to the hate speech. Then obviously what? Law Commission and Supreme Court. Law Commission and Supreme Court has recommended that there should be a specific act to deal with it. Law Commission and Supreme Court has recommended that there should be specific act to deal with it. Specific act to deal with it. Then according to NCRB and ADR, National Crime Records Bureau and Association for Democratic Reforms, according to NCRB and ADR, there is huge increase in hate speech cases in the recent times. According to NCRB and ADR, there is huge increase in hate speech cases in the recent times. Huge increase in hate speech cases in recent times. Now that is the hate speech because it was a kind of current affairs topic. Then films is not necessary here. Cinematograph Act, okay, this that always has been in news. Sham Benegal, those are all not necessary here. Yeah, this one again not in news, but just to know, mention that Shreya Singhal case specifically because it's a landmark case. If not direct question, at least what you can do, you can use that exactly. You can use that particular case or somewhere. Shreya Singhal case. Under that, first write section 66A IT Act. First write that and then you tell why it was declared unconstitutional. Section 66A IT Act. Section 66A IT Act. Any information spread using an ICT device. Any information which is spread using an ICT device. Any information which is spread using an ICT device which is grossly offensive, or causes annoyance, discomfort, which is grossly offensive or which causes annoyance, discomfort, whatever, so many keywords there, dude, will be considered as what? Criminal offense. Which causes annoyance, discomfort will be considered as a criminal offense. Will be considered as a criminal offense. Obviously, what Supreme Court did? Supreme Court declared it as unconstitutional for violating same 19 clause 1 subclause A. Supreme Court declared it as unconstitutional for violating 19 clause 1 subclause A. Unconstitutional for violating 19 clause 1 subclause A. Obviously, what are the grounds they gave? Just mention those reasons. The terms used in section 66A are very vague. Terms means the words like annoyance, grossly offensive, all of those terms used in 66A are vague. Obviously, vague means what? Chances of misuse, misinterpretation is high. Chances of misinterpretation and misuse is high. Chances of misinterpretation and misuse is high. That means what? Chilling effect on freedom of speech and expression. Chilling effect on freedom of speech and expression. Chilling effect on freedom of speech and expression. Then no procedural safeguards to prevent the misuse. Means who will arrest, how will you arrest? No procedural safeguards to prevent the misuse. No procedural safeguards to prevent the misuse. No procedural safeguards to prevent the misuse. To prevent the misuse. And of course, why is it needed? Same logic. 19 clause 1 subclause A is not absolute. What is it? Subjected to reasonable restrictions. It is not absolute. It is subjected to reasonable restriction. 19 clause 2. It is not absolute. It is subjected to reasonable restrictions. 19 clause 2. 19 clause 2. Fine. Now, why is government demanding? Government wants section 66A to be brought back to deal with fake news, deep fake news. Government wants section 66A to be brought back to deal with fake news and deep fake news. Even that also was a question that I keep on framing at least 2-3 years. Need to reframe the 80 Act, Information Technology Act. Right? Government wants to bring it back to deal with fake news and deep fake news. Yeah, broadly those are the aspects. Now, this is constitutionalism, leave that out. Equality, they have not asked it in this aspect, they have linked it to comparison of, yeah, these issues are there. Again, chances of getting a question is not so easy because there are so many argumentations or kind of sensitive issues these are, but broader, putting transgender rights. Transgender right, because of the which issue? Same-sex marriage issue. Third year, I am repeating the question because again continuously one or other way transgender issues are in news, and UPSC has the tendency to go back 2 years, 3 years, you never know, then they will ask transgender rights. First aspect is what? No explicit provision in the constitution related to transgenders. One judgment we have wrote in the morning, probably 2 we wrote, detailedly we'll write, because look at the broader question. No explicit provisions in constitution related to transgenders. No explicit provision in constitution related to transgenders. But obviously, which one do you have? Where's the judgments? Yeah. Judgments. Supreme Court judgment or broadly judgments related to transgenders. Because same pattern repeating. What if they ask, when they ask gender environmental justice, if they ask transgender itself specifically, because morning we wrote about gender justice, broadly which includes women also, is specifically transgender. Write all the cases. First is what? Exactly, NAS Foundation case. We'll write all of them. NAS Foundation. Delhi High Court decriminalized homosexuality. Delhi High Court decriminalized homosexuality. Decriminalized homosexuality. Decriminalized homosexuality. Suresh Kumar Kaushal case. Supreme Court recriminalized homosexuality. This is not in favor of it, but I am telling you all the judgments. Suresh Kumar Kaushal case. Supreme Court recriminalized homosexuality. Recriminalized homosexuality. Then Navteej Singh Johar, Section 377 unconstitutional, gender identity part of 21. Navteej Singh Johar, Section 377 unconstitutional. Section 377 unconstitutional, right to gender identity part of 21. Right to gender identity part of 21. Then Nalsa case. Transgender is a third gender. Transgender is a third gender. Obviously, what they are eligible for? Yeah, they are eligible for the benefits of backward classes. Which warning also we wrote? Eligible for the benefits of OBC, or you can say backward classes. Now, the current affairs angle. Current affairs also last year 23 from 1.5 year. Yeah, exactly. In Suprio case, Supreme Court did not allow same-sex marriage for transgenders. In Suprio case, Supreme Court did not allow same-sex marriage for transgender under Special Marriage Act. Did not allow same-sex marriage for transgenders under Special Marriage Act. Under Special Marriage Act. Fine, under Special Marriage Act. And what Supreme Court did not recognize? Supreme Court refused to recognize civil union. Remember that it was a mid-path. Supreme Court refused to recognize or provide civil union for transgenders. Means just staying together kind of a one, and so that eligible for the benefits. Supreme Court refused to allow or recognize civil union of transgenders. And what they told? Same sex, or not same sex, so you can say right to marriage is not an absolute right. It can be restricted by the state. Right to marriage is not an absolute right. Right to marriage is not an absolute right. It can be restricted by the state. It can be restricted by the state. Can be restricted by the state. Fine. And what they told? State, or in other words, legislature should pass an act to allow for same-sex marriage. Legislature should pass an act to allow for same-sex marriage. Means the Supreme Court refused to do it on its own. They said let the legislature take the call. Legislature should pass an act to provide for, to allow same-sex marriage. This is what Supreme Court told in that case. Legislature should pass an act to allow same-sex marriage. Now, just for you to broadly understand, put the heading arguments favor, arguments against. Arguments against same-sex marriage. Obviously, lot of broader points you will be aware about it. This is third year we are expecting the question 23, 24, now 25. So, whatever favorite, major current issues are there, I have retained them. First one, Special Marriage Act 1956. 1954, okay, Special Marriage Act 1954. Special Marriage Act 1954. Special Marriage Act 1954 was enacted to recognize interreligious marriages. Interreligious, of course, inter-country was enacted to recognize interreligious marriages, not to create new institution of marriage. Means here the marriage definition itself will change, right? Not to create a new institution or new definition of marriage. Not to create new institution of marriage. Then right to privacy includes right to marry, but right to privacy may include right to marry. Privacy may include right to marry, but marriage has a larger public aspect. Marriage has a broader public aspect, hence state can regulate it. Marriage has a broader public aspect, hence state can regulate it. Hence state can regulate it. State can regulate it. Then this one, concerns related to the children adopted by the same sex couples. Obviously, because there is no other option, they have to adopt. Concerns related to the children adopted by the same sex couples. Children adopted by same sex couples, obviously related to what? Issues related to social stigma, discrimination on not only same sex couple, those children. Concerns related to the stigma and discrimination of children, means their emotional psychological well-being. Actually, I think Delhi or some state commission for protection of child rights also raised this concern. If you want, in bracket write state commission, I think probably Delhi or something, or in national commission only. Commission on protection of the child rights expressed this concern. Commission on protection of the child rights expressed this concern. Then that one, same sex marriage will create legal issues related to inheritance, taxation, property rights. It will create legal issues related to, means how will the property go, all those things. Legal issues related to property rights, taxation, inheritance, etc. Maintenance, so many issues will be there. Legal issues related to taxation, property rights, inheritance, maintenance, etc. Then this angle, it goes against the natural order. It goes against the natural order. These are like arguments in favor, arguments challenging, that is against, then arguments in favor. Arguments in favor. Obviously, which arguments will be there? Article 21. Article 21 includes, or dignified life includes. Article 21 includes same right to marry for same sex couples. Includes right to marry for the same sex couples. Then globally, multiple countries have legally recognized it. Globally, multiple countries have legally recognized it. Multiple countries have legally recognized it. Then surrogacy and adoption. Surrogacy and adoption provides opportunities for procreation. Then Supreme Court said that LGBTQ enjoys a bouquet of rights which might be denied. Means they also have the rights related to same tax benefits, inheritance, all of them. Supreme Court said that LGBTQ also enjoys a bouquet of rights, means group of rights which will be denied. Means if it is not recognized, same sex. Supreme Court said that they are eligible for bouquet of rights. So then obviously what we need, way forward, awareness campaigns about the rights of transgenders. Remember there is an act also, Rights of Transgenders Act. Awareness campaigns about the rights of transgenders. Then legislature should clarify or address the issue. Legislature should clarify the issue by amending Special Marriage Act. Special Marriage Act. Then cultural religious sensitivities of the community should be considered. Cultural religious sensitivities of the community should be considered before taking cultural religious sensibilities of the communities should be considered before amending the acts. So that is your same-sex marriage issue. So anytime you can expect the question, as I told. Actually, I had made a broader question also related to abortion, because abortion also continuously in news also last year. Again, not so easy to expect. This one you can include under your social justice angle also. But I think abortion. Last year I had made this because of this context. So read the question, you will understand. Because again 23 question, this one also. Remember, there is a landmark judgment in US related to Roe versus Wade, 1973, in which they are told that right to abortion is a fundamental right. 2023, US Supreme Court reversed it and said right to abortion is not a fundamental right. Now, related to that, and in the same year in India, you had an act, MTP, Medical Termination of Pregnancy Act, was amended, and they made few changes related to the abortion related aspects. So hence we made that broader question related to right to abortion. Fine. Again, very sensitive issue, not so easy to be asked, but if in case they ask, at least broadly, if you want few points there, so you can put the broader heading, right to abortion. At least if not, you can use it for arguments. I'll just some of the core points. Right to abortion. First, Roe versus Wade, US context. Roe versus Wade, 1973. Roe versus Wade, 1973. US Supreme Court said that right to abortion is a fundamental right. US Supreme Court said that right to abortion is a fundamental right. Right to abortion is a fundamental right. In 2023, this judgment was reversed, overruled. 2023, this judgment was overruled. Yeah, now Indian context, write this. In India, it is a statutory right under MTP Act, Medical Termination of Pregnancy Act. In India, it is not a fundamental right, remember, it's a statutory right, means restrictions are more. If you make it as fundamental right, restrictions are less. In India, it is a statutory right under MTP Act, Medical Termination of Pregnancy Act. Just copy the provisions, because if in case they say legal provisions or something like that, at least you should be in a position to write. Please mention this. 1, 2, 3 copy. I think originally it is 1971 or something. They kept on amending it multiple times. Fundamental rights, minimum 1 question, sometimes 2. If they ask basic theory question, like let's say for example, they have still not asked a question on writs. So if they ask a question on writs, obviously the basics you know, those are all theory aspects, you can directly write habeas corpus, mandamus, prohibition, all those things. Something on minority rights if they ask, then that educational rights, article 30 only they need to ask, because last year it was in news. That also I will sum up now, because continuously it was in news in which one, Aligarh AMU case was there, and then some Uttar Pradesh Madrasa Act was there. In that also it was in news. Yeah, I think it's done. Then same. First you put arguments in favor. Of course, larger arguments you can easily generate. Arguments in favor of abortion. Obviously, first you write the keywords: reproductive rights of the women and couple, you can say. Reproductive rights of the individuals and couples, or women and couple. Then right to choose as part of right to privacy. Right to choose as part of right to privacy. Then you can write that case, though not landmark case, Suchita Srivatsav, reproductive autonomy, part of personal liberty under 21. Suchita Srivastava, reproductive autonomy is part of individual liberty under 21. Means broadly the same. Reproductive liberty, autonomy, part of individual liberty under 21. Reproductive autonomy, part of individual liberty under 21. Then India is a signatory of CEDAW, ICCPR, all those things. India is signatory of, write those keywords: ICCPR, ICESCR, CEDAW, elimination of discrimination against women. ICCPR, ICESCR, CEDAW, which recognizes same women's reproductive rights. Of course, in so many acts also, in so many countries also they have allowed it. Then challenging. Arguments against. Obviously, so many angles are there. Cultural, religious conflict. Life begins at conception. That's the argument. Cultural, religious sensibilities. Link to that, or you can write on this argument: life begins at conception. So not only after delivery, life begins at conception itself. Life begins at conception itself. Then misuse of technology leading to female feticide. Misuse of technology leading to female feticide. Leading to female feticide. Female feticide. Then unsafe abortion, 20% of all the maternal deaths. Unsafe abortions is or contribute to 20% of the maternal deaths. So this is the, of course you can use other ones like what? Motherhood. Motherhood is an emotional aspect, not a commercial aspect. Motherhood is an emotional aspect, not a commercial or not a liberty related aspect. It is an emotional aspect and not a commercial aspect. That is abortion related. Of course, very tough to manage or make a balance. Whatever is there, it is better we stick to that, because if you make it as a fundamental right, challenges are very, very huge. So that is transgender, abortion, same sex we covered. Sedition is there. That also is a continuously repeated question. But now you don't have sedition. Just to go through it, I'll, so that you get an idea. You might have come across that provision by now. Recall how many times we have discussed sedition aspect. Now it's replaced by, go through that. Deletion of sedition is welcome and its apparent equivalent. Now you have what? Section 150 of Bharatiya Nyaya Sanhita must not be infused to infringe upon the free speech rights, because in the BNS there is nothing called as sedition. Now we have a term provision called as what? Section 150. But section 150 is more broad. Just look at the wordings. The wordings are any kind of speech, any kind of speech, and what they tell, which tries to either attempt or supports anything related to secession, armed rebellion, subversive activity, separatist activity, anything which tries to compromise sovereignty integrity will be punished. It is more or less similar to which one? Sedition itself, but they have not used the term sedition, because section 150 broadly they call it as what? Deshadroha, treason kind of a one, Deshadroha provision. Now the concern is what? Is it actually sedition, or is it actually more broader than sedition? Because they have used words like any activities which compromises sovereignty integrity will be considered as what? Deshdroh, means life imprisonment or up to 7 years. That's why what they are trying to say, is it like sedition in another new form, is the criticism. Clear? Now for that, continuously sedition question was discussed for a long time. Same things, same provisions actually you can use here also. Just go through the broader provisions, you will understand. Or if you want, just put the subheading. Just I'll sum up quickly, because this is also in news because of the BNS. BNS is also will write, but that will write under your acts, criminal justice laws. Just broadly sum up. Section 124A IPC, sedition. Section 124 capital A IPC, sedition. 124A IPC, sedition. Now what they have done? In BNS, the term sedition is not mentioned. In BNS, the term sedition is not mentioned. The term sedition is not mentioned. It is replaced by, or you can say it has other provision called as, the term sedition is not mentioned. What did they have? It has a provision related to Deshdroh, section 150. Provision related to Deshdroh, 150, section 150. And what the section 150 says, because at least it will help you in your further points. It says that any kind of activities, any kind of speech, anything, section 150, it says that any kind of activities which tries to any kind of activities which tries to support separatist, secessionist activities, any kind of activities which try to support secessionism, separatism, and endanger sovereignty, integrity of India. Endanger sovereignty, integrity of India will be punished with 7-year sentence or life imprisonment. Means nothing in between. Will be punished with 7 years imprisonment or life imprisonment. Seven-year sentence or life imprisonment. That's why what is the concern? Hence, it is criticized that what they have? Section 150 is more broader in scope than sedition. It is criticized that section 150 is more broader in scope. Section 150 is more broader in scope compared to sedition. More broader in scope compared to sedition. Fine, that is why it has been criticized. But what we need to write? But why do we have to retain, or why should section 150 continue? Like for that, these are the arguments. See, more or less same arguments related to sedition, those arguments will not change. Arguments in favor of 150. We used to write the same arguments for sedition also. Same thing continues even here. Expected question for continuously so many years. Last year also we discussed it. Now new questions we need to discuss again. 150. Directly write what? Necessary to combat anti-national, of course same, secessionist terrorist activities. Necessary to address or combat anti-national, secessionist terrorist activities. Anti-national, secessionist terrorist activities. 2. 19 clause 1 subclause A is subjected to reasonable restrictions under 19 clause 2. 19 clause 1 subclause A, freedom of speech and expression subjected to reasonable restrictions under 19 clause 2. Reasonable restrictions under 19 clause 2. Then section 150 tries to protect legitimately elected government. Section 150 tries to protect legitimately elected government from attempts to overthrow it. From attempts to overthrow it. From attempts to overthrow it. Fine. If you want below that you can write Law Commission, 22nd Law Commission. Law Commission also suggested that sedition related provision should continue. I mean section 150 type provision. 22nd Law Commission are also recommended that such provisions should continue. I had also recommended that such provisions should continue. Such provisions should continue. Then Kedarnath Singh case we will write later. Then obviously some criticisms are also there against 150. Compromises or chilling effect on freedom of speech and expression. Arguments against chilling effect. Whenever you have the just use that word, chilling effect on freedom of speech and expression. Chilling effect on freedom of speech and expression. B. Dissent and criticism is part of democracy. Dissent and criticism, part of democracy. Part of democracy. Same like sedition, terms used in section 150 are very vague. Similar to sedition, terms used in 150 are very vague, means chances of misinterpretation. Terms used in 150 are very vague. Terms used in 150 are very vague. Obviously, what Supreme Court had told. Supreme Court in Kedarnath Singh case had narrowed down scope of sedition. Similar, Supreme Court in Kedarnath Singh case had narrowed down scope of sedition. Scope of sedition. Scope of sedition. Similar guidelines should apply to section 150. Similar guidelines should apply to, means narrow the scope, apply to section 150. Then if you want, violates ICCPR, UDHR, violates provisions of ICCPR, UDHR, ICCPR and UDHR. Yeah, so then broadly what you can include, section 150 is necessary. Section 150 of BNS is necessary, but Supreme Court guidelines in Kedarnath provision should be included. Supreme Court's guidelines in Kedarnath Singh case should be included to reduce the misuse. Supreme Court's guidelines in Kedarnath Singh case should be included to reduce the misuse. Kedarnath Singh case should be included to reduce the misuse. Yeah, whenever asked, never say that it has to be deleted. It is necessary. Fine. Okay, so mostly that is your fundamental rights. Just in case they ask about minorities, normally there is no one single question. Mostly it is whatever we discussed in and around. I'll just see if there is any other question that I had framed with respect to Nyaya Samhita, fundamental rights. Constitutional morality, basic structure, constitutionalism, natural justice, all of that we'll write later. Indian Constitution as a living document. Okay, all of those things we have already done. All this is done. I think I made you go through this broader question. Like how we discussed in the morning, more or less same kind. You see this kind of, just to, if in case they ask something, questions related to that. Like remember morning we saw one question, same, that living instrument to address, which has catered to the demands of the progressive society, something like that they are asked. Reframing it in a more broader aspect. Most of the question pointers we have discussed it, just to show to you how to structure it. Concluding introduction part we already know, they have just given some basics. The major, because they have told about amendments, some major amendments they have mentioned, first amendment, 7th amendment, 9th amendment, 73rd, 74th, whatever, some major amendments, and then how it has been given broader interpretation, live with dignity, livelihood, custodial violence, right to privacy, decriminalization of homosexuality, Subhash Kumar, whatever, right to health, reproductive rights of women, LGBT, information, MC Mehta, basic structure, Yeah, so they've only mentioned cases. As I keep telling, what you need to do, write, generate another dimension and write about those other aspects also. That is one way of writing. Then this is for your preamble aspect. Okay, that also we went through that. Which is left out, as I told, there was 9 schedule. Okay, because just to show you the current affairs angle, because remember this was in news last year. Just go look at this. Directly we'll write the question content. Number 9 schedule, Bihar government has proposed inclusion of caste based laws under 9th schedule to shield them from judicial review. There is one question related to that, just to show it to you, and then we'll write it as a mains question. I don't know if they posted it or not. Okay, I think he has not put it here. Just I'll read out the question. Anyhow, we'll do it under your judiciary again. I think I remember that Supreme Court judgment on IR Colo case 2016 they had asked. Now, if in case they ask about right to, which one, not right to, 9th schedule, just put that, put the heading 9th schedule, because it is in news, current affairs angle, and then you will write 1 or 2 answers. 9th schedule, first write the basics. What is it? 31, article 31 capital B, article 31 capital B. This is a broader topic, historical underpinnings. 31 capital B, obviously which amendment? First Amendment 1951. First Amendment 1951. It includes any acts of, any legislations of, it includes any legislations of the union or state, union government or state government, any legislations of union government or state government, or parliament or state legislature, anything, any legislations of the parliament or state legislature related to any subject, cannot be questioned in judiciary. Any legislations of the parliament or state legislature, cannot be questioned. I mean, yeah, cannot be related to any subjects, cannot be questioned in judiciary for violation of any fundamental rights. For violation of any fundamental rights, if such acts are added to 9th schedule. Cannot be questioned in judiciary for violation of any fundamental rights once or if such acts are added to 9th schedule. If such acts are added to the 9th schedule. If such acts are added to the 9th schedule. Obviously, how many you have? There are around 284 acts in the 8th schedule. Just to understand the number, around 284 acts in 9th schedule. 531B. But the landmark case is what? IR Kohlo case 2007. IR Kohlo was the state of Tamil Nadu. IR Kohlo. COELHO. IR Kohlo was the state of Tamil Nadu 2007. COELHO versus state of Tamil Nadu 2007. Supreme Court said that judicial review is part of basic structure. Supreme Court said that judicial review is part of basic structure. Judicial review is part of basic structure, hence it cannot be bypassed. Hence it cannot be bypassed. Now obviously what does that mean? Even if an act is added to 9th schedule, even if an act is added to 9th schedule, judicial review will still apply. Even if an act is added to the 9th schedule, judicial review will still apply. Judicial review will still apply. Under that dual test. Dual test. First one, does the law violate a fundamental right? Does the law violate fundamental rights? B. Is that fundamental right part of basic structure? Is that fundamental right part of basic structure? If yes, the act can be declared unconstitutional. If yes, the act can be declared unconstitutional. The act can be declared unconstitutional, but it will only apply to those acts added to 9th schedule, only apply to those acts acted to the 9th schedule or passed whatever after 24th April 1973. It will only apply to those acts passed after 24th April 1973. Those acts passed after 24th April 1973. Fine. That's actually, if you have seen, there's another one which normally is not very famous one. In this case, Supreme Court had given something called as rights test and essence of rights test. Two tests, essence of rights. Look at the word itself says rights test and essence of rights. If you want, you can write that. In this case, Supreme LIR Colo case, in this case, Supreme Court had given rights test and essence of rights test. Rights test and essence of rights test. Now, what do you mean by that? It's test and essence of rights test. This one, there you can just put an arrow mark or something. Narrow interpretation. Narrow interpretation. Narrow interpretation. Here, judiciary will check if an act violates literal interpretation of a right. Here, judiciary will check if an act violates literal interpretation of a right. Means, is it violating a right mentioned in so and so, that will only they'll check literal interpretation of a right. But what is this? Broader interpretation. For rights test, does a particular act violate a literal interpretation of a right? Here it's a broader interpretation. Judiciary will check if the act violates essence of a rights, not only the literal interpretation. Judiciary will check if an act violates or if a provision violates essence of an act, essence of a right, not only literal interpretation of a right. Fine. Yeah, continuously they keep applying. If you have seen, remember last year Bombay High Court in one of the case had told that there is something called as this, which one, in the digital media regulations they had put, what do they call it as? Supreme Court declared, Bombay High Court declared it as unconstitutional. Fact check unit was there under some digital media rules. Means government will fact check it if the whatever opinion or something expressed on social media is correct or not. If the fact check unit feels that okay, so and so provision is not legally valid, it is an unnecessary criticism on government, it will be considered as what do you call this, violating fundamental right, unconstitutional. So if you look at broadly, it feels like okay, fine, provision is correct, because only if it is violating a fundamental right, it will be declared as unconstitutional. If you take it as rights test, it is directly violating a right or not, they'll check. But essence means what? Okay, the provisions deeper interpretation they'll go. Okay, to what do you mean by this fact check unit? Okay, in the theoretically you will tell that only if it violates fundamental right you will declare it as unconstitutional. But what they'll go and check, how will you determine what is necessary, what is valid criticism of government or not? On what is a parameter on which you will check it? All those very deeper meanings they'll go. Then if they feel okay, superficially it looks like it is not violating fundamental right, but at the depth it still is violating fundamental right, then also they will declare it as unconstitutional. Means essence, they will go to the core of it. So narrow, broader. As of now, Supreme Court applies this essence of rights test. Normally we don't discuss that because not a single question on all of them, but Supreme Court had told that in which case? IR Kohlo, rights test and essence of rights test. Fine. Yeah, so like that, because I mean, why is it in news? I think I forgot to mention that itself. Just mention that why is it in news first. Yeah, exactly. Write that first. 9th schedule, it is in news because of demand by Bihar and Jharkhand government to include their reservation based, almost 75-80% reservation. It's in news because of the demand by Bihar and Jharkhand government to include their reservation based laws which crosses 50% limit in 9th schedule. To include their reservation based acts which crosses 50% limit in the 9th schedule. 50% limit in the 9th schedule. I think there was another question related to fundamental rights. I think that's very easy. Recall there was another question in 2022. Right to movement and reside. I mean 19 clause 1 subclass D and subclass E, which is not absolute, it is subjected to reasonable restriction. Very basic question they had asked. Right to movement and right to residence because of the COVID context and all those things. Recall that we keep telling that right to movement is also not absolute because what one? On the grounds of general public interest, on the grounds of ST, it can be restricted. You have what? 5th schedule provision, 6th schedule provision, rights of scheduled tribes, inner line permit, or during COVID times also freedom of movement was restricted for the larger public interest. Rights of persons affected by HIV, Supreme Court in, not Supreme Court, Bombay High Court in which one? Lucy D'Souza was the state of Bombay. People affected by HIVs, their movement can be restricted. Not landmark, I mean what landmark case because of the HIV, I mean people affected by HIV aspects. Same way right to residence, right to settle, temporary and permanent, that also can be restricted. Same 5th schedule, 6th schedule, outsiders cannot, even ILP for that matter, outsiders cannot go and permanently settle there or buy property there, all those things. Same things. Very theoretical, not necessary to be written. 6th schedule will write later, 142 is related to judiciary, hate speech we wrote, EWS we wrote. UCC, continuously in news related to DPSP. I'll show you the question also. If possible, minority one is because of the AMU case and Uttar Pradesh Madrasa case, it was in news. Only related to 30 will write. Then we'll directly go to DPSP. Put the heading Article 30, Educational Rights of Minorities. Because 2 judgments you had last year 2024. Article 30, Educational Rights of Minorities. Educational rights of minorities. First write the constitutional provision, then we'll go to the current affairs. After that, we'll start with your DPSP. Educational rights of minorities. Obviously, what the 30 clause 1. Minorities have the right to establish and administer educational institutions. So you need to write the provisions exactly in the answers. 30 clause 1. Minorities have the right to establish and administer educational institutions. Minorities have the right to establish and administer educational institutions. Establish and administer educational institutions. 30 clause 2. Mandatory compensation for minority educational institutions. 30 clause 2. Mandatory compensation for minority MEI, minority educational institutions, if their property is acquired. Mandatory compensation for minority educational institutions if their property is acquired. In bracket 44th Amendment 1978. 44th Amendment 1978. Obviously, there are so many cases, because of that aspect only we are writing current affairs angle. Whenever you get this first case, what you have to write? TMA Pi Foundation was the state of Karnataka. Fundamental rights is the most important thing for your prelims mains perspective also. TMA Pi Foundation was the state of Karnataka, 11 judge bench. 11 judge bench. Article 30 is not absolute. State can regulate it. Article 30 is not absolute. State can regulate it. State can regulate it. Yeah, what do you mean by state can regulate it? Below, state can regulate it. Under that, of course, they also told another provision. If you want, you can write that. Both religious and linguistic minority should be recognized based on the population of the community within the state. Both religious and linguistic minority should be recognized. Both religious and linguistic minority should be recognized based on population of the community within the state. Means not the country. Both religious and linguistic minority should be recognized based on population of the community within the state. Population of the community within the state. Then legislations related to or you can say general legislation. Legislations related to minimum wages, labor rights, minimum wages, labor rights, protection of women applies to these institutions also. General legislations related to minimum wages, labor rights, protection of women applies to them. Then state can regulate. State can regulate. State can regulate admissions of students, fee, syllabus, examination, teachers' qualification, admission of students, fees, syllabus, that is curriculum, teachers' qualifications, etc. Fine, that is one. Now other one is what? St. Stephen's College, up to 50% of seats can be reserved for their own community. St. Stephen's College case, St. Stephen's College, Delhi. Up to maximum 50%, up to 50% of the seats can be reserved for their own community. Same was in CMC, that is Christian Medical College, Vellore, that also not necessary, reserved for their own community. Then recent cases you write. In AMU case, Aligarh Muslim University case, in AMU case, okay, for that first you have to write, in bracket you write first, which one? Aziz Basha case. Aziz Basha case. Supreme Court said it is not a minority institution. Aziz Basha case. Supreme Court said it is not a minority institution. It is not minority institution. Fine, but recent context is different. Clarify that. Which an AMU Act was amended and recognized as a minority institution. AMU Act was amended in 1980s. AMU Act was amended in 1980s and recognized as minority institution. Recognized as minority institution. Allahabad High Court declared the amendment unconstitutional. Allahabad High Court declared the amendment unconstitutional. Declared the amendment unconstitutional. Supreme Court stayed the judgment. In other words, as of now, it is still Supreme Court has stayed the judgment. Last year's again, that was the last year context, has stayed the judgment. Then recently Supreme Court upheld Uttar Pradesh Madrasa Act as constitutional. Current affairs angle, these are all. Recently Supreme Court upheld Uttar Pradesh Madrasa Act as constitutional. Madrasa Act as constitutional, and who had declared as unconstitutional? Allahabad High Court had declared it as unconstitutional. Allahabad High Court had declared it unconstitutional. Allahabad High Court had declared it unconstitutional. There is another current affairs angle. Supreme Court upheld West Bengal Madrasa Service Commission as unconstitutional. Supreme Court upheld West Bengal Madrasa Service Commission Act as constitutional. Supreme Court upheld West Bengal Madrasa Service Commission Act as constitutional. Under that A, religious education autonomy for madrasas. Religious education autonomy for madrasas. Religious education autonomy for madrasas. B, secular education in madrasas, state will regulate. Secular education in madrasas, state will regulate. State will regulate. And these are because continuously 1 hour of the time it has always been in news. So keep that in mind. And remember 1 year that asked that question also, it was in controversy some 3-4 years, almost I think 2018 or 19. There is no reservation in which one? Minority educational institutions. That's why again it was actually AMU algorithm Muslim controversy itself. NCSC, I think NCST also had told that reservation should be applied in a minority educational institution, but Supreme Court again stayed that. And so if you want that also, just as a context you write, few years back NCSC and NCST had recommended, not recommended, yeah, maybe recommended itself. Few years back NCSC and NCST and NCSC had recommended that minority institutions should provide reservations, same obviously for SC and ST. Minority institutions should provide reservations for SC and ST, but Supreme Court stayed it. In other words, it was not implemented. Supreme Court stayed it. Fine. Yeah, so anything related to 30 if you get because of the current affairs angle in news, so at least you should be in a position to know the major judgment, because same pattern. Article 30 Supreme Court case laws illustrate. If they ask, never ever miss out on especially TMA Pi, St. Stephen's, AMU. These three are landmark cases of Article 30. If you write any other case like West Bengal case or something else, if you have seen in Lakshmikant, they have told Kerala, Malankara, Syrian Catholic, although you write them, but you don't write TMA Pi, you don't write St. Stephen's, I think still now they have still not added them in Lakshmikant. Then your answer will not get value because those are the landmark cases. Malankara Syrian case is not a landmark case related to 30. Okay, fine. So now related to your, I think that's broadly fine with respect to your fundamental rights. Now let's look at DPSP. Only one case, one question related to DPSP, which you know, but again in news multiple reasons. But before, okay, if you want question you write, or we'll write some basic provisions related to DPSP, then we'll come to this. First putting DPSP. DPSP. Fine, part 4, 36 to 51. Only mains content I will tell. Part 4, DPS, 36 to 51. 36 to 51. Under that, directly mention the kind of a mind map or something, features of DPSP. Just mention it like this, because again these pointers you may have to use in your arguments whenever there is a DPSP question. Obviously first one, which one? Welfare state, yeah, that also will write welfare states. The moment you get DPSP, welfare state, or in bracket you can say social economic democracy. Welfare state, social and economic democracy. B, of course, non-justiciable. 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 C, theory aspect, derived or similar to whatever. Instrument of Instructions 1935 Act. Remember, very basics. Similar to Instrument of Instructions 1935 Act. Instrument of Instructions 1935 Act. Fine. Then article, okay, that is fundamental to the governance, fundamental principles of governance, fundamental principles of governance, fundamental principles of governance. A broader aspect. Now write which one? The moment you write fundamental principles of governance, bracket article 37. Article 37. Then descriptions, another subheading. Remember all those various ones, like we wrote, how you wrote for preamble. This we also normally write in your OGP class also. Granville-Austin. Now which one? Granville-Austin. FR plus DPSP equals conscience of constitution. Granville-Austin, US political scholar. FR plus DPSP equals conscience of constitution. Conscience of constitution. Ambedkar, novel features of constitution. Ambedkar, novel features of constitution. Novel features of constitution. Then MC Chagla, CHAGLA, Supreme Court judge. Recall what is it? If DPSPs are truly implemented, India will be heaven on earth. If DPSPs are truly implemented, India will be heaven on earth. India will be. These statements, why are we writing? Because you can use them easily in your introduction and conclusion when you write DPSP question if they ask something directly. MC Setalwad, Attorney General of India, or First Law Commission Chairperson. MC Setalwad. MC Setalwad. DPSPs are beacons of light to the court. DPSPs are beacons of light to the court. Beacons of light to the court. Beacons of light to the court. Then significance, all those things. If you want that also, another subheading you make. Significance. This also we write. Significance. Significance. First one, common manifesto for all parties. 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 Fine. B, certainty in policies and programs. Stability in the policies and programs. Stability in policies and programs. Stability in the policies and programs. Fine. C, opportunity for opposition and people to question government. Opportunity for the opposition and people to question performance of government. Question performance of government. Then non-violent silent revolution. Non-violent silent revolution. Non-violent silent revolution. Right? So then you have that FR versus DPSP aspect, but for us most important is what? Current affairs angle also, PYQ also. Even in normally also we discuss that UCC. So the heading Article 44, Uniform Civil Code. Fine. I think broadly you will be knowing the content part, right? So try to, it is, can you, I'll just brief it once if in case you have forgotten, listen to it and then try to write the answer. Fine. So try to recall what do you mean by UCC, how do you define it as? A uniform civil code, it's a different aspect. What do you call this? Definition, application of the same law with respect to the personal civil aspects like marriage, divorce, all those things, irrespective of the religions. That is the definition that you have to write. Obviously, so what is the context, historical context? Ambedkar Hindu Code Bill, or before that Serbian Rao codification of Hindu personal law is the context. Because of that only the concept of UCC got, what do you call this, continuously been in discussion. Then what are the arguments in favor of UCC? What all are the arguments in favor? Women's rights angle, okay, fine. Secularism angle, correct. Exactly, simplification of laws. Then global, okay, global angle obviously to an extent, so many, because in so many even Muslim countries itself that is there. Then which one, sovereignty and integrity, because you will be applying the same laws. Supreme Court has supported it in various cases, recall Shabano, this, that and everything. Then challenges, few challenges are there. Obviously, you will be knowing which one, freedom of religion for minority, freedom of religion in general or minorities, 29, all those things. Homogenization, okay, that means, I mean here homogenization means what do you call this, fear of apprehension of imposition of majority laws on the minorities. For scheduled tribes, there are so many exceptions under 5th schedule, 6th schedule, 371, how will you implement them? Fine, and then it is non-justiciable. How are you trying to make it, what do you call this, mandatory? Should. And Law Commission in one of the reports I told, it's neither necessary nor desirable. Now all these are various argumentations. Fine, try to write an answer, because if I tell the overall content, then it will become, what do you call this, very difficult for you to, I mean it will become very easy, very easy for you. Exactly same things, please write, or I will make a question, you write it, more or less similar. First write the question. In the context of continuous debate on, in the context of the continuous discussions, debate, whatever, context of the continuous discussions on Uniform Civil Code, UCC, context of the continuous discussion on UCC, discuss its need, and challenges associated with it, discuss its needs and the challenges associated with it. Fine, that's, I'll take it as a question. I have given you the structure itself, please sit and write. It's 7:10 now, you have till 7:20 in detail, right from definition to the historical context a little, and then take it as a 15 marker itself and write the significance, write the cases, write the challenges. If in case you know some way forward, please write them. It's a very famous expected question. If you, and then I'll brief it, anything left out you can add. Just 1 second, if you want I can make the, add the timer. ರಾಕೇಶ್ ಇಲ್ವಾ ನಿಮಗೆ ಅದರಲ್ಲಿ ಟೈಮರ್ ಆ್ಯಡ್ ಮಾಡೋಕ್ಕೆ ಬರುತ್ತಾ ರಾಕೇಶ್ ಕರೀರಿ ಇಲ್ಲಿ Okay, done. I think you have already taken 1 minute extra also. Okay, so I'll tell the broader structure. So, and then see if you have matched according to it. If in case you want to add any pointers, you can add it there. So, obviously, because the question is on UCC, how can you define it first? First, define UCC. I'll tell you how. Please tell anybody definition of UCC. Just now I told you before writing. Application of the same law with respect to the personal civil matters like marriage, divorce, inheritance, etc., irrespective of the religious identity. So this is the definition. So that is first aspect you have to mention. Of course, where is it mentioned? Article 44 of the Constitution calls for it. Clear? Then just in case if you want, again, because you took it as a 10 mark, I mean 15 marker, 10 minutes, Sir B.N. Rao committee, what had recommended for what? Codification of Hindu personal law. Then who had drafted it? Dr. Ambedkar had drafted it. And so based on that, gradually it was split and passed into separate laws. If you recall, Hindu Marriage Act, Hindu, remember that Maintenance Act, Guardianship Act, and then Special Marriage Act, all of them. That's a broader context. Then arguments in favor, or what you can say, because the question uses the term as what? Need for UCC, use the same subheading called as need for UCC. And as I told, what are the arguments you can use? First, uphold sovereignty, integrity of India. Why? By applying same law for all. Because same law when you apply, it feels that we all are one aspect. Two, uphold secularism, because what it keeps out of? Because it keeps religion out of legal issues. That is secularism aspect. Third, why is it needed? Correct, simplification of the complicated personal laws. Because personal laws are very, very complicated, you can simplify that. Then, if you want other ones, states like Goa, Uttarakhand already has that. Then, protection of which one? Whose rights? Rights of the vulnerable communities, especially women. Example, controversial or provisions related to triple talaq, polygamy in Muslim personal law were largely criticized for violation of women's rights. Correct. Then which one? Global practice, as you guys told, you can write that also. A lot of countries, including Pakistan, Turkey, already have laws related to UCCs. I mean, Muslim countries, if you want to take that. Then Supreme Court in what all cases? Shah Bano case, Shaira Bano case, exactly, Sarala Mudgal case, and so many other, Daniel Latifi case like that, so many are there. But three, yes, you write. Shah Bano, Shaira Bano, Sarala Mudgal has supported UCC. If you want political angle, leaders like Ambedkar, Nehru, Vajpayee, Kalam have already supported it. Like these are all various arguments to say this, yes, we need. But what are the challenges? First major challenge, Constitution it provides which one? Special provisions under 5th and 6th schedule for scheduled tribes. And so that you can't implement against them. Then 371 also. Special provisions or exceptions under 371 for states like Nagaland, Manipur, even I think Arunachal Pradesh also. You can't implement these laws on them unless who agrees? Unless their state legislature agrees. Nagaland, Mizoram, in Manipur, all of them. Then what? Yeah, chances are also there, because first of all DPSP is non-justiciable, and you have what? Freedom of religion, rights of minorities, 25 to 28, 29, because 30 is educational, that also you have, and non-justiciable angle obviously. Then Law Commission said it is neither necessary nor desirable. Understood? Then apprehension of, as we told, which one? Apprehension of the imposition of majoritarian provisions, means majority Hindus provisions on minorities. That apprehension is also there for a long time. Of course, way forward, what you can tell? First major, what you have to tell? Multi-stakeholder consultation, including with whom? Religious community leaders or community leaders, whatever. That is first necessary point. Second, Law Commission should come up with a detailed report. Law Commission, the Supreme Court has already told to do that for Law Commission. Then in the short term, what we can do? Separate laws can be passed for Muslims and Christians by the Parliament itself on the constitutional values. Separate laws to be passed by Parliament for Muslims and Christians based on constitutional principles. Same equality, liberty, all those things. Long term, what? UCC should be the goal. So there are still so many other arguments, because Article 44, remember, uses the term shall, if you have seen. State shall secure UCC for the citizens. So that's why under arguments in favor, some people argue that what? Because the word is used, you use this shall, what does that mean? Yeah, constitution makers expected that Parliament should pass a legislation. These are all various arguments in favor and in against, and it's a very, very very popular topic. I don't even have to say how much has it been in discussion. So that should be the broader structuring of your answer. Keywords, highlight them. Definitions are very important. Sir B.N. Rao Committee, Ambedkar, Supreme Court cases, and the provisions like which all? 5th schedule, 6th schedule, 371, all of those. Law Commission saying not necessary, not desirable will matter a lot. If you write in general, so you are not, and the definition itself you have to write specifically with respect to what? Personal civil matters like marriage, divorce, inheritance. If you generally write application of same law for all irrespective of religion, it's a very generalistic definition. Evaluator will not be impressed, because they will easily understand that what? Okay, you only know it as general, application of same law. That anybody will tell. You have to tell personal civil aspects like so and so. Unless you don't say that, you are not hitting what? You are not eyeing to the exact demand of the question. Right? Broadly, these are the ones. Of course, because fundamental rights will take a lot of time. Then few other aspects are there. Basics of the Constitution in this first subtopic, which is a little detailed. Second, like comparison of Constitution, separation of power. They're all relatively easy subtopics. Then we'll see. Then federalism. Almost you can say out of 10 days. So polity part will take 4 days. Governance 1.5. Social justice maximum 2.5, 3. Then IR 2 to 3. So 10 to 11 days broadly that is what? 5 plus totally 4. 5 plus 4 for governance, social justice, 3 or normally 2.5 for IR. So that is how we have divided. Not even 5, 4 you can say, 4.5 for polity. Because federalism, parliament, you all know, judiciary, those 3 will take little more time. Fine, okay. So we'll end for today. We'll meet again tomorrow. So what you have to do is, please go read it. And some students were asking that, sir, will it be enough for this means? Absolutely enough. You don't have to do anything extra. Of course, few any bills or something they bring, that you have to keep on adding. First, what you need to do? Make that you revise them properly. Understood? Sit and try to write answers again. Please keep a timer and write. Even when you write in your home, anywhere, room, a PG, anywhere, please keep a timer and write. Never ever write without a timer, or else you will not even get to know the real demand of mains. You are writing this mains, you are writing next year mains, doesn't matter. From now onwards, whenever you write answers, please keep a timer. Sir, but I am not able to write. It's fine. Push yourself. At least then you will be like, okay, in 7 minutes I am only able to write 1.5 side, or one like let's say 1.25 of a side. That indicates that you are still have to improve your speed, or at least you will understand definitions are not flowing, arguments are not flowing. That means you have still not revised the content properly. Sit back, again revise the same topic, again write within time. UCC, let's say if you are not able to write, go back and revise the same content. Again keep a timer, again write. Again you are not able to, again keep a timer, again write, or bad. And another myth is there that you should not bad, it's an intellectual exam. It's that itself is a myth. The myth is not that, the myth is that it is an intellectual exam. It is not an intellectual exam. 100% it is not. Brace broadly analysis part, everything you need some multi-dimensional aspect. It's not an intellectual exam. It's not like a Harvard Law School professor, Oxford Law. There is nothing like that. It's a degree, especially in mains exam, degree examination with a huge competition. That's the game. Competition is what differs. And of course, questions are little bit analytical compared to your normal, what do you call this, typical degree examinations, understandable, no doubt about it. Competition is what it differs. So keep that in mind. Lot of pointers, arguments, everything by heart. Don't hesitate to by heart, because we are told to. I mean, because of the way our examination has been there, like rote exam, rote learning kind of a one. We keep on telling, especially in degree, graduations, post graduation, they tell us understand. Of course, yes, you need to understand, no doubt about it. But so many things you need to by heart. Keywords you need to by heart. Judgments you need to by heart. Articles you need to by heart. Don't hesitate to by heart. For mains, by heart matters a lot. Like how, literally like how you by heart your tables, remember in your childhoods, like that you need to by heart. Don't hesitate, because I am telling you, it's a mental block that we should not by heart for this exam. You have to by heart, especially mains. Prelims, it's a different aspect, because you have to just eliminate, you don't have to by heart literally. Here, if you don't by heart, at that moment, how will you generate? It has to come, I mean, especially fact part I am telling. Sometimes arguments part also, it's a combination of analysis and memory. Fine, how much is this, how much is that? As of now, you can say 50-60% is analysis and argumentation, or maybe 2/3, but at least even now 30 to 40% is your facts and by heart part. Don't, what do you call this, kind of take it lightly. And so note down all those whenever you write, make some short notes, write down important judgments, write down articles. Same way in GS-3 there will be so many things, write down those, what do you call this, maps, this, that, so many things are there, reports, facts, IMF facts, World Bank facts, Niti Aayog facts, economic survey facts, and write it down at one place. Anyhow, I have made short notes, I'll give it to that, I mean, I'll forward it, but it's better you keep noting it down. Clear? Last minute revision matters a lot. N number of times you have to revise, at least 10 times entire syllabus if you are writing this, what do you call this, mains. When you are writing next mains, it's fine. But my suggestion is, even if you are writing next main, means considering you have relatively less course in prelims, don't take it in a little lethargic way that okay, anyhow I am writing next mains. Prepare as if you are going to write this mains. At least you are push yourself. Anyhow you will get another, because August end itself is a mains. By within August your mains is completed, whoever is writing this mains. Those who are not writing this mains, anyhow you will get another September, October, November, December, 4 months again. You can do another 2 times revision at least. If you consider that it will anyhow next mains, then you will keep on pushing, and we know the more and more you keep postponing, you will not get that intensity. So don't postpone. Even if you are not, if you are writing, obviously yes, this mains. If you are not, prepare, tell yourself that you are writing this mains and prepare with that's the same intensity. Please what do you call this, make some group or mingle with those who are writing this mains, along with their own intensity, you also prepare. Then you will get another round. If you neglect it now, you are not going to get chance again. Again you have to come back next time, again you have to do the same. Because everybody by now, you know, I have told multiple times, mains is the real game, because you look at the marks, whatever, 4 GS plus essay plus 2 optional, how much, 1750 plus 275. So that means out of 2025, 1750 means you calculate the percentage, probably 80 or probably more than that. So that means I don't have to tell how important is that. So keep that in mind and do with the same intensity. Please don't postpone. The more you postpone, the more is the problem. Fine? Okay, revise, go back, revise, literally by heart, write again, keep timer. Especially for those writing this mains, I am again repeating, please don't write a single question without timer. It's very, very important. If you want to write the same question, select 3 questions, keep timer 30 minutes, write it as a 15 marker, or let's say you are choosing a 10 marker, keep 7.5 or 8. 10 plus 10 plus 8, keep 28 or 27 minutes, right? 2 15, 110. And so push yourself. The more you push yourself, the more you will identify your limitation. Or else you'll be like, okay, let me write again. You'll start serious answer writing by July end or August first week. By that time you can't correct. Your presentation issue, I've told morning also, please don't hesitate. Join handwriting classes. Write those copy books. Never ever hesitate. Do whatever it takes to be in the list. Whatever it takes. You bring in your ego, you are postponing your success. Fine? Okay. We'll come back again in the morning. Those who are writing this mains, please dedicate at least 2 to 3 hours for optional also. This mains I'm telling, especially those who are very in the safe zone, because optional, my suggestion, don't take it as, okay, 10 days only I'll keep it for optional, next all, don't do it like that. Every day, give morning maybe whenever you get up, because we'll be having by 10 or 10:30, morning 2 hours or 3 hours you give it for optional, finish it off. Or morning you revise this content and then till here you give it, then go back and try to see if you can give 2-3 hours for optional. My suggestion, do it in the morning, because going back and again going, if you do 6-7 hours of this class and then again going and doing it for 2-3 hours of optional, not so easy. That's what I feel. If you are comfortable with that, it's fine for you. But minimum 3 hours for optional, please don't neglect. Optional needs a very, because even if you look at the notification also, a little more deeper understanding. And you will not get that hold if you do it for, okay, before result only I'll read and then I'll come back in August and again I'll read. Optional, you will not get that hold like that. Every single day you should do optional. Fine. So you can say like 5 to 6 hours of GS, or let's say because the classes are going on 6-7 hours, you can say 2 to 3 hours at least, 1 hour, whatever you have revised, whatever. In the class, whatever we do, you revise it for 1 hour. Here, those who are rating this mains, increase the effort to 10 to 12 hours. So you don't have any other scope, especially those rating first mains or second mains. Those who are rating third mains, fourth mains, they'll have all their foundation ready, short notes ready. They have, if they have got interview call, they know how to tackle it. That's a different aspect. Those kind of people obviously will not be in these kind of classes as of now, unless they have scored very less in GS-2 or GS-3. They may take those. Understood? So foundation is ready, different. First mains, second mains, different ball game. Okay, fine. We'll come back again in the morning. Thank you.